provision of the Constitution. And that is to say, therefore, Your Honor, that it cannot be limited whatsoever. And of most importance, Your Honor, is Article 50, Clause 2, Paragraph N of the Constitution. Your Honor, when the Kenyans enacted this Constitution, they were aware of such kind of occurrences, and therefore they codified the common law doctrine of Njiru sine lege by making a specific provision in the Constitution which provides that not to be convicted for an offense, for an act or omission, that at the time it was committed or omitted was not an offense in Kenya. That is the doctrine of the Njiru sine lege that was codified. That is to say, Your Honor, as I sum up, you have to interrogate this charge vis-a-vis the provisions of Section 16 of the Cyber Crimes Act. When you go to Section 15, Your Honor, subsection 2, it will interpret for you what interference is contemplated. That's Parliament made this provision. For purposes of this section, an interference is unauthorized if the person whose act causes the interference is not entitled to cause that interference. Remember, the suspect, Your Honor, is here because she has responded to a public invitation through the parliamentary website that obviously expects reactions from the members of parliament. Public, Your Honor. That is therefore to ask, can that be perceived to amount to interference when Parliament has invited the members of the public to react to the finance bill? Number 2, Your Honor, you look at subsection 2, paragraph 2. Does not have consent to interfere from a person who is so entitled. By the mere fact that a publication of the website was provided to the Kenyans, there is a prima facie presumption that there is an unfettered and unexpressed consent from any member of public to send emails, be they massive emails, be they one email. Therefore, the question is, does the publication and the provisions of those websites that our client is deemed to have interfered amount to the consent by Parliament? Number 2, finally, Your Honor, look at section 57 of the Criminal Procedure Code. It gives you the power, Your Honor, to admit or to fail to admit a charge sheet. If a charge sheet does not square out in law, Your Honor, this court has the capacity under section 57 of the CPC to fail to admit. And what will inform you whether or not it discloses an offense? The particulars contained therein. If our client was to be invited to respond to the invitation by the DPP, 1, would she be sufficiently be informed to understand the cause of the offense that she's pleading to? Does it disclose an offense? Do the particulars disclose an offense sufficiently enough to inform our client whether to answer to a charge of guilty or to a plea of not guilty? Finally, Your Honor, this charge that has been brought before you must be read in the light of public policy, in view of what the country is currently anticipating. That the state is at the verge of introducing a punitive finance bill, and they do not want the members of public to react to it. Finally, Your Honor, read this charge sheet in view of Article 10 of the Constitution, as well as at 118 of the Constitution, where the Constitution has directly invited members of public to participate in the legislative process. If you admit this charge as it is, Your Honor, it will amount to you violating the provision of the Constitution where members of public are actually supposed to participate in a process. So the admission of this charge will act as a clawback to the constitutional gains that the country has attained. I am most humble.